All right, I got so excited I rolled my sleeves up. It's time to get down to business on how to increase value in your cases. I want to talk about two things: speed, and then ways to think outside the box that can get you information that the defense does not want to provide and then would rather settle the case. So let's talk first about speed, then we're going to talk about some specific examples of ways that you can increase value. Speed. I know that after 25 years of running my own practice, that cash flow is the most important thing about financial success. If I have $1 more than I need for the rest of my life, then I'm rich beyond my wildest dreams. It doesn't matter if I make $1, $1 million, $10 million, $100 million. As long as I have the cash flow that allows me to do what I want to do at the time I want to do it. So cash flow is a direct function of how fast you move your cases. It also is a reflection of your ability, your efficiency, your knowledge, the type of leopard that I say, because leopards don't change their spots. And you're telegraphing to the other side, to the carrier, to the defense, that you know what you're doing, that you know how to do things, by how fast and efficient you can be in your litigation or your pre-lit. So let me give you some examples. Right? If you serve a complaint within 20 days of service, you can notice the deposition of the defendant or any depo. So right off the bat, once 20 days after service comes up, we notice the defendant's depo. Now, we know that it's likely going to be objected to, unilaterally said, and you needed to tell me before so I could give you dates, etc. We know that's coming. But if my first inquiry was not to notice the depo, but instead say, hey, can you give me some dates for your client's depo? Those dates are going to be, one, they're going to respond 3 weeks later. Well, my client's busy. And then those dates are going to be like 9 months away, 4 months away. No. I want to 20 days after service, notice the defendant's depo. And that's going to be in another 20 days. Sure enough, 15 days later, the defense lawyer is screaming, you literally said it and we're not available. But I want to push the case forward. So our office saying, we get it. We're happily going to move it to a new date, but it's got to be very close in time. And once we get that new date, we're going to take the old date off calendar. Now, what have I done? Now, I've taken that depo probably 2-3 months sooner than I would if I had waited for the defense to just give me some dates. So now my time on desk is at least 2 to 3 months earlier. Plus, many times for cases to settle, it requires the depos to happen. So the sooner I can make the depos happen, the faster the case resolves, the better my cash flow is, the happier my client is, the more they will refer me to other people. And I'm also telegraphing to the defense that I'm not ready to wait and take bullshit. I love my case and I want you to move. By the way, while I'm pushing for the defense depo and they say, it's unilaterally said and we've got to give you a new date, I'll say, I'll take it when you give me a new date close in time. Oh, by the way, my client's ready to be deposed. I'll waive notice. You need to do a defense medical exam? I'll waive notice. Again, get moving. Let's go. Because if the depos happen, the medical exam happens, and that happens 3 months earlier than it normally would, same case, same facts, same issues, it just settles 3 months earlier. Cash flow. Another great example is when the defense goes, Mike, hey, you want to mediate this case? What normally happens between that? All this time is wasted. Mike, would you like to mediate? Sure. A week later. Sure. What mediators would you suggest? Week and a half later. Well, we would accept Jim. A week later. Sure. Jim's great. Why don't you call? Okay. Then they call a week later. Jim's available in 2 years from now and 4 years from now. No, let's pick somebody else. And back and forth, blah, blah, blah. Sometimes it takes you 3 months to get a mediator and then another 3 months to get it scheduled. So instead, let's think about how you speed that case up. Mike, let's mediate this case. And that's as a separate issue after I've already made a policy demand. If they've said no, I've already gone above it. So I've set up the parameters of a positive mediation. But let's just say, Mike, let's mediate. So then I will call, or my office will call, 5 or 6 different mediators that I would agree to. I would get dates, but dates in the next 2 to 3 months. They may have dates for the next year, but for the next 2 to 3 months. And so my letter back to the request of let's mediate is, I will accept any of these 5 mediators. Here are their available dates that I'm also available at, but I'm not giving them any dates past 2 months from now. Because if you give them a date 2 months, 3 months, 6 months, and 9 months from now, guess which one they're picking? The 9 month. So now I've just short-circuited months, weeks, months by giving them multiple options with multiple days that were available. They pick one, done. Now you have a mediation in a couple of months or a month or 2 from now, and you've short-circuited all of that. Speeds the case up. Telegraphs what kind of lawyer you are, what kind of leopard you are, because people who do that know the system, know that cash flow is king, know that I want to get my shit done so I can get to trial. That means I try cases. That means I spend money on cases. That means I don't take bullshit answers or offers. That means I've already set it up with a 998, and if you didn't pay it, I'm over it. And when we go to mediation, I'm starting at that number far above the policy. What does that result in? Way more money, way faster, happier client, which is really the most important thing. But now I make money, they make money, cash flow is king. I have now more money to hire more people, do more marketing, enjoy more stuff, buy more boats, planes, trains, whatever it is, right? Or for me, sheep, goat, chickens, more donkeys, etc. But you have more stuff. You're also telegraphing what kind of leopard you are. Now, while you're doing that, you understand that in a litigated case, there's basic stuff, discovery, written discovery. By the way, special interrogatories, I have stopped doing. They're such a waste of time. After 9 months, you wind up getting watered down, objections, whatever. They're appropriate for very specific, I need the name and address of so-and-so. But form rogs, requests for production, depositions, right? Once you're done with that, the defense has done a defense medical exam, and you're like, well, we're stuck. The trial date's 2 years from now. They're just going to wait 2 years. Here are some examples. So I have created a list, and it's laminated. So come on, that means it's important, of a whole bunch of things to think about ways to increase value, ways to protect the value in your case. And at the Trial Lawyers University in Huntington Beach in June, I'm going to talk about this kind of in full. But a couple of examples that you should think about and reach out. It's on my AlderTalk resources and all my social media, but you can also just reach out in the bio or the video description for it. A notice of inspection for the forensic inspection of the defendant's phone with an expert. Well, that gets their attention right away. The first thing the defendant is going to ask their lawyer is, why do they need my phone? I'm not giving them my phone. Why hasn't this case settled? Wait a minute. You mean that they offered to settle this within my policy limits and you said no? What the hell's going on? Settle the case, done. Because you ain't getting my phone. That gets their attention. Now understand that defense lawyers are just like us. They got way more work to do, especially in-house counsel. They got 1,000 cases. And if you think about it electronically, but you put it into like a visceral context, they got cases stacked up in their office electronically everywhere. What you want to do if the case has got like a trial date from a year from now is you want to make them metaphorically pull that file out and start looking at it. You forensically examine the defendant's phone. You got their attention. Have you been to the scene? Go. You learn stuff. You see signal lights. You see signs, and you see grassy areas and obstructions of views that you never would have seen had you not been to the scene. Have you been to the plaintiff's home? Have you sat on the couch in their living room or in their kitchen? You notice all sorts of stuff. Suddenly their injury, they can't use the blender the right way, or the guitar that's sitting in the corner and you're like, what's that? And they go, oh yeah, I forgot to tell you, I used to play guitar, but I can't anymore. You learn so much that gives you information. If you're in the plaintiff's home, they have family photos on the wall that they don't have a copy of to send you, but you go and you take a photo. That's now great evidence and exhibits. Those are things that, show the family relationship, the happy times. All of that stuff you learn by going to the plaintiff's home, right? Have you done a search of your own client, an ISO, other similar incident? I'm not sure what ISO, but anyway, it's a list that the insurance company has done of claims, comp, PI, insurance claims that the plaintiff has done in the past. Many times the plaintiff innocently doesn't remember that 15 years ago they got into a fender bender and made a claim for their property damage. And then suddenly in the depot they look like a liar, but if they didn't disclose it, and it's simply not a big deal, but you want to protect yourself by looking at ISO. There's a whole bunch of stuff. Have you looked at your client's social media? Have you looked at the defendant's social media? Have you put the defendant or the defendant company into ChatGPT and say, tell me about this defendant? You will learn amazing things. What's the relationship between the driver and the company if it's a vicarious liability question into ChatGPT? What's the information or the relationship between the defense expert and the defense law firm? ChatGPT will tell you a ton of stuff. Have you summarized your medical records? Not with a bullshit AI product that just gives you general summaries, but specifics. You find stuff in there that maybe you had missed. A Cripps diagnosis, something else. And then you can run that summary through chat and say, tell me generally what the information finds about prognosis. Tell me about inconsistencies. Tell me what type of doctors that are here that we are listed, but we should have their records and we don't have them. All of this stuff is helpful for you to get because when you get that new information, you provide it to defense. Metaphorically, they got to pull that file out. And when they focus on your case and they see that you're moving your case along and they see that you've asked for the phone and they see that you're giving new information, they go, why can't we settle this case? The Freedom of Information Act. Have you sent a free letter to the government for complaints about the dog, about this intersection, any other accidents that happen at this intersection, right? Any other trip and falls, any other criminal acts? The Freedom of Information letter, which I'm happy to provide, very basic. But you want to do chat, provide a Freedom of Information letter that asks for the following types of information. It'll draft it for you. Right? Have you canvassed for witnesses? We just did a press conference yesterday where we're looking for a particular person who was with this girl right before she fell off a balcony to her death. And the press conference yesterday with a partial photograph and a sketch, we already found the guy. The police have been looking for this dude for 3 months. The black box information, the electronic data is now in most cars. So when you get into a collision, there is a box, a data recorder that for 5 seconds before the collision, it records things like accelerator and brake use, turning, yaw, speeds, right? Seatbelt use. You're going to want to try to get that from your client's car and the defendant's car. There's a whole host of different things that we can talk about. Life care plans, voc rehab plans, but reach out. Go on to my social media and AlderTalk resources and download ways to increase value. Come to Trial Lawyers University in Huntington Beach in June. Come say hello. Come listen to my speech. Watch it on video. Watch it on YouTube. Watch it on my Instagram, my TikTok, etc. But also reach out. I'm happy to brainstorm. I love this stuff. There's no strings attached. Not looking for anything. Good works is good karma. Helping people is a good thing. I get a lot out of that just because I like it. Is it good business? Hell yeah. But it's also great karma. So please get out of your own way. You're not bothering me. You're not important enough. I'm not unimportant enough. You're not too important. I'm not too important. I'm not too busy. You're not too busy. I won't respond. I will. Get all that crap out of your head and just reach out. My info's in the bio or the video description. Come on now.